Okay, it is 10 o'clock and we'll get started here. I want to thank everyone for choosing to be with us this morning for our webinar. Um, so the HRC is hosting these webinars each Tuesday at 10 o'clock to try to provide some resources to the community specific to COVID-19 and to try to touch on some issues within our purview, that the community may be having, some issues they may be having. And today specifically, we're focusing on employment. We have with us this morning Brian Shoemaker. He is the Outreach Education Coordinator out of the Indianapolis District Office of the Equal Opportunity Commission. Brian, I know the EEOC has put out some guidance specific to COVID-19 and as it relates to the Americans with Disabilities Act and the Rehabilitation Act and other EEO laws. And I'll turn it over to you.
Okay, thank you very much, Crystal. I appreciate it. And thank you, South Bend. I really do appreciate being able to chat with you today. While I am getting my presentation up here, just so that we can see, I think, let me quick get back here. So, Crystal, do you see my presentation up there?
Yes, it is.
Okay, perfect. Okay, so what I'd like to do today is just talk about a few things that's related to COVID-19 and the EEOC. The best thing I can tell you, though, is that most of this information, in fact, all of the information that I'm going to be talking about today, will be on our website, and I'll give you our website information. I've presented this specific program twice already, and it seems like every time the day after, new updates get listed. So, this is an ongoing, issue with us. And so I really would like to make sure that the most up-to-date information is always going to be on our website. So again, my name is Brian Shoemaker. I am with the Equal Employment Opportunity Commission. Just to give you some information about the EEOC, just so that we're all on the same page. The EEOC is an independent federal agency, and what we look into is we look into complaints of discrimination in employment. So you have to have an employer-employee relationship before you can file a charge with the EEOC. That's one of the things that we look for. That's the jurisdiction that we have. And we deal with discrimination in employment. The EEOC has 53 field offices nationwide. The ones that are in this district in particular, this is the Indianapolis district, and that covers all of Michigan, all of Indiana, all of Kentucky, and half of Ohio. So that's our region. And real quick, these are all the laws that are enforced by the EEOC. The two laws that we're going to be focused on today is the Americans with Disabilities Act, and we're also going to deal a little bit with Title VII and some harassment issues, just to make sure that that's covered as well. And for some people, this may be, you may be able to look at those laws and say, I know exactly what those mean, no problem. But I think for most people, this is a better way to find out or to realize what the EEOC does. And the EEOC looks at discrimination in employment because of your race, your color, your disability, genetic information, religion, national origin, sex, which includes pregnancy, and your age, which is 40 and older. So if you feel you're being discriminated against or even harassed because of one of these issues or these protected bases, that's something that the EEOC can look into for you, and we can try to help you in that situation. Basically, all of our laws distill into these protected bases. So what are we going to do today? Well, I'm hoping, first of all, and really the most important thing is that you know how to find updated information regarding COVID-19, specifically how that relates to employment. Okay, that's going to be the most important thing that we discuss today. We're also going to talk about some of the current guidelines related to Title VII of the Civil Rights Act of 1964, especially and with an emphasis on national origin discrimination. So we're going to talk about that because that is something that we have been seeing recently. We're going to understand some of the current guidelines with the Americans with Disabilities Act and how that relates to COVID-19. And really importantly, we're going to know that reasonable accommodations are still required under the Americans with Disabilities Act. So today I am only going to be talking about issues that deal with employment, so your employer-employee relationship. If you have any other questions or any other issues that relate to COVID-19 and aspects of employment, they are probably going to be covered under the DOL, which is the Department of Labor. So any wage and hour issues, the new specific laws, the Family First Corona Response Act, that's all going to be under Department of Labor, and they would be a better resource to contact rather than the EEOC. One of the big things that we've been seeing is OSHA complaints. So if an employee does not feel safe working in the environment, their employer's environment, that is probably going to be more likely an OSHA complaint rather than an EEO complaint. Okay, so that's just something to remember. And Department of Labor has great resources on their website. I would highly recommend you take a look at the DOL's website to get information and first see if your questions can be answered by the Department of Labor. The EEOC has an excellent website devoted to coronavirus as well. We have several different resources up there for you, including a frequently asked questions that is actually it's updated constantly. There's a webinar that the EEOC did that's really excellent, and I would highly recommend you can check that out. It's on YouTube. The link is on the EEOC's website. There's also a transcript for that, and you can read that if you don't feel like going and watching the video itself. And we have some other information about your rights under the COVID-19 and the ADA. So I would highly recommend going there first before you do anything, because they're going to have the most updated information. The other thing I will say today is, because we may be talking about some issues related to disability and medical information, I would request that if you have a comment or a question, you can certainly ask that, but what I might tell you to do is just to email me later or even call me, and I'll put my information, my contact information up at the end. That may be better, especially if we're talking about sensitive information, because this is kind of a public environment. It may be better to ask those questions to me, privately, either through email or a phone call. And so I may be, I'm glad to take any type of questions, but it may be that I refer you just to answer it or to ask that question through email or phone, and that may be the best way to contact me anyway. So let's get right to it. The first thing that really I want to mention to employers and employees is that nothing has really changed as far as our discrimination laws. The first responsibility for an employer is not to discriminate. Okay, so nothing has really changed. The employer still has a duty to not discriminate in any and all aspects of employment. Harassment is still a form of discrimination, and we are still looking at harassment issues and charges. And in particular, now that there's a workforce that is maybe more working at home than not, we want to include that cyberbullying can be an extension and be included within the realm of harassment. So we want to make sure that these are real issues that we want to talk about, and we'll talk about some of those ways to prevent that type of harassment in just a bit. But I did want to make sure that we talk about these harassment issues, because the EEOC has seen an increase in national origin discrimination, specifically, or in particular, Asian Americans and other people of Asian descent. So we want to make sure that we understand that harassment is still an issue, and that there may be certain groups that are being harassed at a greater because of some of the issues that come with the COVID-19 pandemic. And so I want to talk real briefly about ways that we can prevent harassment and then what to do if you feel that you're being harassed because of your national origin or really for any other particular. Harassment is a new challenge now that a lot of people are working at home. So one of the ways that we're talking about this is that harassment can come in the form of miscommunication and also lack of personal connections. People feel isolated, and isolation can oftentimes lead to feelings of harassment by your employer. So I want to give some helpful hints and some advice for people that are working virtually. And so, what you can do as a virtual employee, some ways to prevent harassment from occurring. And if you feel that you're being harassed, what do you do? And then for employers as well, what are some best ways to try to avoid this harassment that may come because people are working more from a virtual standpoint? And the first thing I wanted to talk about is miscommunication. So the best thing to do is to make sure you have a conversation with your employee, or if you're an employee, have a conversation with your supervisor, your employer, about what are the best ways to communicate with you. We have all written that email, or at least received an, and we've gotten, and you're just confused about what is actually going on. Like you don't understand why this person is so mad at you. This email, we've all had those experiences, or we've written in, and just before we've hit return to send it, we've said, maybe this isn't the best email to send right now, because we're trying to, you know, we may not be prepared for that medium. So one of the things to do is just find out what's the best way to communicate. Communicating in person through teleconference usually is the best way. You can see somebody, you can have a conversation, you can communicate with a person more effectively than you can over email, and there's less chance of the email being misinterpreted in ways that may make a person feel that they're being discriminated against. And so, and maybe it's not video conference, maybe it's just telephone conference. That's fine too. But a good way to do that is just by asking the employee, or if you're an employee, talk to your employer. Say, this is how I would like to be communicated. It's the best way for me to communicate. And then address issues right away. If there's an issue or a problem, bring it up to your employer. If you're having an issue or problem with something, make sure your employer knows right away so that they can act on that. And likewise, if you're an employer and someone is complaining about something to you, make sure that you make that issue a priority. And we want to try to solve those problems. It's more important now to solve these communication problems immediately, because it's harder to communicate when we're all working in a virtual workplace. The other issue that we see is this lack of personal connection. And when people feel isolated, they can sometimes feel as if discrimination is occurring or harassment is occurring. So we want to try to bring people together. And that can simply be through some team activities. There's lots of team activities on the web, so on the internet. So I'm not going to list every team activity you could do. But if you're interested in forming a virtual team activity, I would suggest looking on the internet. Lots of suggestions for you there. Also, a buddy system. If you're an employee, you may know a coworker that maybe you've talked to every day. Every day you go in and you have a conversation with this employee who's your coworker, or maybe you have a couple coworkers that you can communicate regularly. Make sure that you're still communicating. If there's an informal chat software that you can use, or maybe just even picking up the phone and making that call and having that water cooler type conversation that you would normally have had, makes people feel included, makes people feel like they still belong to the company and that they're important and the work that they're doing is important. And that's an important concept that we want to make sure that our employees feel, and we want to make sure that if you're an employee, that you make other people feel that they're still connected, because it reduces the chance that someone's going to feel isolated or harassed or discriminated against. And so what happens if you do feel like you are being harassed? Well, if you're an employee, you need to follow your employer's policy. What does your employer say about filing or about complaining about harassment? And if you're an employer, you still want to follow your employer's policy. So if someone complains to you as an employer about harassment, follow your guidance. What would you normally do? Nothing has changed just because people are working at home. If someone is complaining to you about harassment, it's still your job to follow your policy. Likewise, if you're an employee and you feel that you're being harassed, now is the time to make that complaint or bring it up to your supervisor so that they know and that they can work with you. The most common response, believe it or not, the most common response to harassment is not to report it. And so it is more important in times when we are working remotely to make sure that you are reporting harassment if you see it. So now what I'd like to do is take a little bit of time and talk about specific things regarding COVID-19 and the ADA. We're going to go over reasonable accommodations. We're going to talk about direct threat, and we're going to talk about disability-related questions and medical information. Really, the reason we're talking about this is because when a pandemic occurs, there are certain things that change with the ADA, and it really deals with reasonable accommodations and direct threat. And the reason that is because of the CDC. The CDC can change the way that we perceive what a direct threat is. And I want you to be aware of that once the pandemic is over, things will go back to, and I'm putting this in quotes because people can see me, will go back to normal, okay? So the ADA, you're going to look at the ADA just as you would normally. The only reason we're looking at the ADA differently is because the CDC has announced that there's a pandemic and that COVID-19, and this is important, COVID-19 can be considered a direct threat. And that's why some things have changed. So let's get really into the specifics of this. And I will say, in complete honesty, this is probably going to be directed more towards employers. You will find lots of good information about COVID-19, and you'll find some good information about the ADA as well. But a lot of the stuff that I'm going to be talking about right now probably applies more to an employer than an employee, but it's still good information. But I just thought I'd let you know before we get into it. So first off, reasonable accommodations. The good news is nothing has changed as far as reasonable accommodations. An employer must still accommodate an individual with a disability. That is still required of employers, okay? So what is a reasonable accommodation? Well, a reasonable accommodation really is any change in the work environment or an exception to work policy that would allow a person with a disability to have equal opportunity in the workplace. And that includes hiring, that includes promotion, that includes any kind of essential functions of the job. It includes any aspect of an employee's job. That person can ask for a reasonable accommodation. Okay, and employers still must accommodate individuals with a disability during the pandemic. Okay, one thing to think about if you're an employer is this aspect of an undue hardship. So one of the ways that you would not accommodate somebody is if the accommodation presented an undue hardship, right, with significant difficulty or expense for the employer. Now, normally, a significant expense for the employer, that's going to be something that the EOC would say is it's going to have to be pretty significant. We're not just talking about a couple $100s, we're talking about thousands of dollars, okay, for most employers. Normally, we wouldn't look at but now since there is some difficulty and there may be employers having issues meeting their own expenses, that there is a possibility that an undue hardship could affect the significant expense for the employer. So that's something to consider for the employer. And then the significant difficulty, that may be something that you want to consider too. How difficult is it going to be to provide this accommodation? Again, usually that is a pretty high burden to overcome for an employer. And I don't want you to think that we've lowered the bar at all, but there may be some differences in your own employer. As an employer, there may be some differences that you have now and some more significant problems and hurdles that you'd have to overcome for the undue hardship defense. If you're going to say this is an undue hardship, that's why we're not going to accommodate that individual. One of the things also with accommodations is that they may change. So just because You had an individual that did not need an accommodation when they were working at your physical location. Now that they're in a new location, they may need a reasonable accommodation, and they can certainly ask for one, and you go through the reasonable accommodation process just like you would normally. Um, Again, when people are transitioning back to work, there may be issues now where they need an accommodation now that they're transitioning back to work, and that's okay. That's something you still have to look into and still deal uh, with reasonable accommodations. If someone asks for a reasonable accommodation, you must interact with that process. And it is reasonable to assume, this is for both the employer and the employees, it is reasonable to assume that there may be timeliness issues if you have to purchase new supplies or purchase an accommodation for somebody. There may be timeliness issues, and the EEOC does. And so while we always ask that accommodation process happens as quickly as possible, we do understand now that there may be some delays in that due to some issues of supply chain and just getting equipment for your individual that needs it. So let's talk about direct threat. This is really the biggest issue. And really the direct threat is a defense that use and say, well, here's the reason why I'm doing something that I would normally not do. And mainly that is either asking for medical information or some other issue, maybe not providing an accommodation because there's a direct threat. And so the direct threat is really, it's a significant risk of substantial harm to the health or safety of an individual or others that cannot be reduced or eliminated by a reasonable accommodation. Okay. And so that is the direct threat. Now, normally when I talk to employers, what I would normally say is if you as an employer are starting to use the direct threat defense, or that you want to use the direct threat defense, now is the time to talk to your legal counsel. Now is the time to talk to your general counsel, somebody that does this quite a bit and has extensive knowledge about the law, because the direct threat is an affirmative defense. Okay, it's a legal term that you would use, and there's the burden of proof now is on you, and so it can be significant. And so that's why I would always suggest, and now is no different, that if you're going to think about the direct threat, you still want to have maybe you seek recommendation from counsel, because it is very specific. A direct threat, okay, is not something that you just are assuming, right? Direct threat has to be based on very factual information, okay? It is not on subjective perceptions or even irrational fears, okay? So it has to be something that's objective and factual. And that's why you would do what you needed to do. And then you also have to consider a few things. You have to consider the duration of the risk, the nature, the severity of the potential harm, the likelihood that the potential harm will occur, and the imminence of the potential harm. Okay, so these are things that you definitely still want to consider. And the EEOC on their website, we're making it, iterating the fact that the direct threat still has to be looked at. You still have to analyze your decision through the lens of direct threat. Okay, and the reason why we're even saying this, or this is even something that's being talked about, is because the CDC has said that COVID-19 is a direct threat to others, to a person and others. And so if someone has COVID-19, that could be, you could use then the direct threat defense in why you're using a medical exam or why you're doing something else to that employer or employee, okay? And it may change as soon as the guidelines change. Then we're talking about, changing the way that we would look at direct threat defense. And so we bring up direct threat because direct threat really allows you to do certain things that you would normally not be allowed to do. One of those things is asking for medical information from current employees. So I'm going to give you just a quick reminder. With the ADA, there's certain times you can ask for medical examinations and medical questions, and certain times you cannot, okay? And so one of the times you cannot ask for medical information is pre offer. Before you offer an employer or a potential employee a position, you cannot ask them medical questions and you can't require them taking a medical exam. Once you have, and that still holds true, once you have offered the position to the individual, okay, you made a post offer. That person is now good to go. Everything has been cleared. Their background check, all their licenses that they need, it's all been cleared, and you're ready to offer them a position. You can offer them a position, and then say this is a post offer exam. We're going to ask questions, and we're going to have a medical exam for you to do. And at this time, this is when you're able to do your medical exams that to test for COVID, as long as you do it for every employee. Okay, you don't want to just do it for one employee. You want to make sure that you're doing it for all employees for medical exams. For a current employee, you would normally not be able to give a medical exam to a current employee or ask them medical related questions. Normally, you would not be able to do that. But since COVID-19 is a direct threat, that gives you the ability to ask those types of questions, okay? Because you're using the direct threat defense. The reason why I did this thing that I'm not normally supposed to do is because it poses a direct threat. And so because COVID-19 is a direct threat, you may be able to do things like screening your employees. That could be with temperature checks. It could be other things as well. But you just want to make sure that whatever screening device you use is in line with what the CDC recommends or your local authorities recommend. So how much information may an employer request from an employee who reports feeling sick? You have an employee, they report feeling sick, okay? Normally, you would not be able to ask a lot of questions about this. But because it could be a direct threat, if that employee has COVID-19, you would be able to ask certain questions now that are related to COVID-19. Okay, so you are allowed to ask employees that are feeling sick questions about their symptoms to determine if they have COVID-19. The CDC and your public health officials have information on what those symptoms are and that information, and so please consult with that information. You don't want to just be making up things and like, oh, I heard on Facebook that this is what people who have COVID-19 report these types of things. You want to make sure that you're using guidelines from the CDC or your local public health officials when asking those types of questions to determine if they have COVID-19. One thing to think about when you're going to be taking the temperature of current employees, you can do this, okay? Remember, the reason why you're allowed to do this medical exam that you normally wouldn't be able to do is because of the direct threat that COVID-19 possesses. And so if you're going to do it for all employees, you do want to think about, will those employees be in contact with other employees? And if those employees that you're taking a medical exam for, which is a temperature, if they're not going to contact any other employees, you may really want to consider whether it is a necessary exam to take, whether those employees do in fact pose a direct threat to other employees if they're not going to be interacting with other employees. So if people are teleworking, okay, they're not going to be interacting with other employees, they may not pose a direct threat to the health and safety of others. And so giving them a medical exam would not necessarily be a good idea, okay? In fact, it probably would not be permitted. And whatever the results of that medical exam, which is temperature, all right, that's confidential information. That's confidential medical information, and you still need to apply that the way you would any other type of medical information that you get from an employee, okay, in a separate medical file. If it's just one employee, so let's say there's one employee that you want to take the temperature of, you really need to examine whether or not you have a reasonable belief based on objective evidence that that person might have COVID-19, okay? And it's the USCA has kind of revised its original, or maybe just updated its ask questions. You want to make sure that it's not just one symptom. Just because someone coughs doesn't mean they have COVID-19, and now they need to have all these medical exams or they need to be terminated or whatever. What you want to do is you need to go through what the CDC and your public health, your local public health, and what they recommend and what they say are the symptoms, okay? And based on factual evidence, okay, objective factual evidence that that person may have COVID-19. And then you still have to look, is this person going to be in contact with other employees? Are they teleworking? Or are they actively involved with other employees? Do they have a direct threat to other employees? Okay. And if they refuse, take some time to think about, or at least ask them why they refuse, because they may be refusing because they have a hidden disability that they don't want to, and there's no need to disclose to you as your employer. Okay, so you may have to talk to them about that. A blanket refusal isn't necessarily something that you do want to have a conversation with that individual about that if they just refuse. Okay, and confidentiality still applies. So whatever medical information you get, the result of that test is still going to have to be something that is kept in a separate medical file and confidential. So again, may an employer send employees home if they display symptoms of COVID-19? Well, again, look, you need to think about the direct threat defense. Is this person going to be a direct threat? Look at the CDC guidance. What types of symptoms are they exhibiting? Okay, do they match or meet what the CDC or your local health authorities are saying? Would they be a direct threat? Are they going to be a direct threat to other individuals? Are they in contact with those individuals? And then, is there an accommodation? Could there be accommodation that would lessen the threat of that individual or make that person no longer a direct threat? Maybe that person can work at home, okay? And they can telework then if they have some of these symptoms. And so that would be an accommodation that you could do and something that you need to consider. So for employees that call in sick, employers can ask employees questions if they are experiencing the symptoms of the pandemic virus, which would be the COVID-19. Use factual information for the symptoms, and then maintain that information in a confidential medical record. Okay, it's still confidential medical information. Can you require your employees to wear protective equipment? Yes, an employer may require employees to wear personal protective equipment, but there may be issues of reasonable accommodations that apply at that time. So if you're asking your employees to use medical, protective equipment, that's fine. But if someone is wearing maybe someone has a wheelchair, make sure that the equipment can fit over that wheelchair, still is able to protect the wheelchair. Someone maybe has some sort of allergy, or maybe some other condition where they can't use latex. So maybe you have non-latex gloves as an accommodation. And even issues of some people who maybe are hard of hearing or have difficulty hearing. They may read lips, and now that faces are covered, they may be an accommodation that they require to be able to do the essential functions of the job. Okay, so just making sure that is that type of protective equipment, you can provide reasonable accommodations for those individuals. Okay, one thing that you do not have to worry about is, if you're going to make sure that your employees hand wash regularly, the coughing and sneezing etiquette, proper coughing and sneezing etiquette. Those are not normally going to be issues as far as that implicate the ADA at all. Okay, so it's just kind of the personal protective equipment that may need accommodations. And just to kind of wrap up here, again, this is the information that on the EEOC's website regarding coronavirus. It's very good. I would highly recommend going here first if you have any questions, because this is going to be the most updated. They update this very regularly. So this is the most updated information. This is a great source of information for you as an employer and as an employee to get information about the EEOC, your rights, when we're talking about COVID-19. And then lastly, just want to give you some of my contact information. So if you have questions regarding the EOC, employment rights, and COVID-19, or actually just anything, you can always reach out to me, and I will do my best to answer those questions. Because of the nature of a lot of the questions that we may get based on the ADA, I think that's the best way right now to contact me so that I can talk to you about individual issues. And then as an employer, feel free to contact me. I'm also the small business liaison, but if you're a large business, I'll still talk to you. So you can give me a call and we can chat about those issues. My phone number, 463-999-1132. And you can always email me at brian.shoemaker@eeoc.gov. And so now I will ask Crystal. Crystal, do we have any questions for me?
No, there are no questions in the chat. If anyone has any really quickly, we can try to address them if you want to quickly get them in the chat. But Brian, I certainly appreciate you being with us today. I had a question.
Sure.
So a person who has COVID-19, they would be considered a person with a disability under the act and would be able to file, or?
A great question. That's a great question. As of right now, um, the EEOC does not have a definitive answer for that. There may be, they have COVID-19, they may not be showing any particular symptoms, and so they may not need an accommodation. They may not be considered significantly. Well, it's a hard question to answer, but what I would say is that that would be something that you would want to talk to me or talk to an EEOC investigator to see. But the EEOC doesn't right now consider COVID-19 as a disability.
Sure.
So, but that doesn't mean you can't be discriminated against. They may be ways that you may be regarded as disabled or something like that. So you do want to consider it, but it wouldn't be necessarily considered a disability at this time.
I see. Thank you for that. And so you said a person could be regarded as, and I'm specifically thinking if a person had COVID-19, they've recovered from it and returned to the workplace, and people still may be leery, about them, and they may start to be treated differently or harassed or whatever, and that could be regarded as. Is that correct?
It could be regarded, or it could be record of. So you had a record of a disability, right? So absolutely. So those are ways that you could, because it could be a record of a disability in the fact that that at the time you had COVID-19, and this is why it gets tricky. You may have had it so severely it does limit one or more major life activity, right? And so that's what we're looking at. And so it depends. That's why it's tricky, because it really depends on how severe, how limited the disease caused you to be. So that's one of the things. But what I do want to make sure people understand is just because you have COVID-19 doesn't automatically mean that you are disabled or you would fit under the disabilities, the ADA. So it really depends on how limited you are and substantially limited in major life activity.
I see. Thank you, Brian. Thank you. And as he mentioned, the EEOC updates their website on a regular basis regarding COVID-19. So there may be some other guidances coming down. And we'll
Absolutely.
have to check that. Okay, thanks, Brian. There are no questions in the chat, in the queue. So I just want to thank everyone for, again, joining us today, participating in this webinar. Next week, we will have, as facilitator, the co-director, Deanna Moya. And she will have Lon Medelson, who's a regional director, Region 5, Office of Fair Housing and Equal Employment from HUD. So that's next Tuesday at 10 o'clock, and we hope everyone will join us again. Thank you again, Brian, and thank you everyone else.
Thank you. I appreciate it.